Welcome back to this course on copyright and related rights law. In today's session, we are going to be looking at composite works and ownership issues. As you know, this week we are focused on discussing unoriginal works, sound recordings and cinematograph films. Having understood how these are copyrightable subject matter despite being unoriginal, and having understood the justification for copyrightability of such subject matters, in today's session we will see how copyright ownership questions arise wherein a sound recording or a cinematograph film which has underlying works could have other owners of work. How then do these relations get managed, and if they don't, what kind of solution exists in law? Let us first understand what we mean by a composite work. As we had discussed in the previous session, a sound recording or a cinematograph film can be a very simple work wherein a sound recording can just be a recording of some sound. It need not be a recording of any particular kind of work. Same is the case with a cinematograph film. For example, if you were to turn on the video camera on your mobile phone and simply head outdoors and capture a scene from nature, then there is no specific work which you are capturing. But is it a cinematograph film? It is arguable that it is. Because in terms of meeting an objective assessment, it is a visual recording in which there might be sounds which are also getting captured. But where there are different works that have come together in order to form the sound recording as a whole, in such a scenario, we are saying that the sound recording would be a composite work. What does composite mean? It simply means made up of several parts, and the parts here we are referring to as works. There are different works which have come together in order to form the whole, which is a sound recording or a cinematograph film. Ask yourself, how many works can make up a sound recording? Let us start with a basic kind of work which would be needed in a sound recording, which is musical work. But even with respect to musical work, can we not say that there may be more than one musical work which is being used, and therefore more than one composer who is part of the same sound recording? Similarly, can we also not say that where lyrics are part of a sound recording, there might be more than one lyricist involved? Therefore, the copyright of such composer and composers, or lyricist and lyricists, how do they overlap with the rights of a sound recording producer? When we consider these underlying works, such as musical works and literary works, we must remember that these musical works and sound recordings do not just appear on the sound recording. In order for the music to be recorded, there must be some kind of a performance. All of us understand that now very clearly. A musical composition played on a piano by a pianist can be recorded in a sound recording. Similarly, a singer singing lyrics in a studio can be recorded, thereby recording the lyrics as well as the underlying musical composition. The question of performers and their rights and how they fit into this equation is something that we will look at in our future sessions. But for now, let us focus on the element of work which is forming part of a sound recording or a cinematograph film. Because this is an arrangement, let us consider this as an arrangement for now, a generic understanding. We are not looking at this in a lot of depth into what kind of an arrangement is it. But when we start asking questions such as this, on whether this is a contract of service or a contract for service, it will have its own application in terms of how ownership will vest in these concerned stakeholders. In a contract of service, such as an employment contract, you would understand that in such a relation, the employee is acting within his course of duty in the time of the employer, using the employer's resources in a duty which he has been assigned, which is quite different from a contract for service, in which we are possibly considering an independent contractor who is not bound by any such mandate on fulfilling a particular duty. For instance, if a person were to go to a tattoo artist and pay him to get a tattoo, the tattoo artist is working as an independent contractor. This basic difference between contract of service and contract for service informs our discussion to a very great length. As we will see, a basic norm in copyright is that the author or the creator of the work is the first owner of the work. But depending on what kind of an agreement exists in terms of that particular creation, that could have a direct impact on ownership consideration. Let us consider a contract of service. As we were understanding, in a contract of service, because the relationship is based on an outcome dependent on a course of duty, we can say that the producer would be the first owner of such a work, and it wouldn't be the scriptwriter. But what if the script is pre-existing? Let us say, for example, that a scriptwriter has written a script and now he's approaching producers to produce a film based on the script. In such a case, because this is not a contract of service, there is going to be a level of negotiation that is going to come in terms of what kind of transaction the scriptwriter will engage with the producer in terms of the copyright. On this point, let us understand how such a transaction can take place. We had understood that in order for copyright to be effected, the right holder must authorize usage of the work. In other words, any person who is looking to utilize the work in a particular manner would have to seek prior authorization of the original author. As we had seen, because this is not a contract of service, because there is a pre-existing work, the scriptwriter's authorization is necessary. How will this happen? The scriptwriter can choose to simply engage in a license, or the scriptwriter can engage in an assignment. What is the difference between these? In a license, there is no transfer of ownership from one party to another, whereas in an assignment, ownership does get transferred from one party to another. What we must also note is that both licenses and assignments can be limited by duration and territory. For instance, the license could be restricted to a period of 5 years, based upon which at the end of 5 years, there could be a scope for renegotiation of the terms. That could be possible. Depending on what kind of usage is allowed, it could be exclusive usage, it could be non-exclusive usage, If it's non-exclusive, then the party who has been licensed is not the only person who can use that work in that particular way. There can be others as well. Consider this question. If underlying works are separate from the recording, through a contract of service, can a producer own copyright over all the works? Just now, we considered the point of what happens if a script is pre-existing. You must have realized that when we had this discussion, we had it on the consideration that the scriptwriter is the first owner. But this is completely opposite to a situation of contract of service wherein the producer will be the first owner. Therefore, even though we are in a position to differentiate between a work which is part of a composite, in other words, we can clearly make a distinction between the script and the cinematograph film. But because it is a contract of service, are we then saying that the producer has ownership over all the copyright that the scriptwriter enjoys or would have enjoyed if not for a contract of service? On this point, let us take a look at one of the most important cases in copyright law that have arisen in India, decided in 1977 by the Indian Supreme Court. This is Indian Performing Rights Society Limited versus Eastern India Motion Pictures. In this particular case, the court was considering this particular concern, what we were trying to answer, and necessarily this was a reflection on Section 17 of the Indian Copyright Act, which, as we were discussing, states a general norm that the author of the work, the creator of the work, is the first owner. But to this norm, it provides certain exceptions of specific relevance to our discussion, and in this particular case is Section 17 Clause B and 17C. Let us take a look at what these provisions are saying. Section 17, as you can see, talks about first owner of copyright. It says, subject to the provisions of this Act, the author of a work shall be the first owner of the copyright therein. Clause B. Subject to the provisions of Clause A, in the case of a photograph taken or a painting or portrait drawn or an engraving or a cinematograph film made for valuable consideration at the instance of any person, such person shall, in the absence of any agreement to the contrary, be the first owner of the copyright therein. In this particular provision, you can see the person who is making the valuable consideration, that person is going to be the first owner. You can look at Clause C now. In the case of a work made in the course of the author's employment under a contract of service or apprenticeship to which Clause A or Clause B does not apply, the employer shall, in the absence of any agreement to the contrary, be the first owner of the copyright therein. I'm sure you can, on bare reading of Clause B and Clause C, make a clear line of distinction between the two. Where one provision talks about contract of service, the other provision doesn't talk about a contract of service, rather talks of a situation where there is valuable consideration for the making of a particular work. As you can see, it says, in the case of a photograph taken or a painting or portrait drawn or an engraving or a cinematograph film made for valuable consideration at the instance of any person. So, because a particular work has been made for the instance of a particular person, it is that person who will be the first owner. Now, please note, when we talk about first owner, it means that the entire gamut of rights under Section 14, which we will discuss in the future sessions, but just to be aware of the different kinds of rights that are available to authors, We can say there are reproduction rights, there are distribution rights, adaptation rights, translation rights, etc. Now, there is no distinction in what kind of right will vest with the producer, for example, and what will vest with the script writer, or what will vest with the composer. No such distinction is made. It simply says that the producer will be the first owner. Now, let us look at how the Supreme Court in this case is looking to answer the question. First, the Supreme Court looks to explain what cinema is. The court says, a cinematograph is a felicitous blend, a beautiful totality, a constellation of stars, if I may use these lovely imageries to drive home my point, slurring over the rule against mixed metaphor. Cinema is more than long strips of celluloid, more than miracles in photography, more than song, dance and dialogue, and indeed more than dramatic story, exciting plot, gripping situations, and marvelous acting. But it is that ensemble which is the finished product of orchestrated performance by each of the several participants, although the components may sometimes in themselves be elegant entities. The Supreme Court points out that there is a purpose to the making of cinema wherein the audience is captured within its magic, and this is only possible if we see cinema as a distinct entity different from the component parts which in themselves are elegant. On the question of separation of works, the Supreme Court refers to a very important provision within the Indian Copyright Act, which is Section 13, Clause 4. You would remember, Section 13 talks about works in which copyright subsists, and 13.4 states, the copyright in a cinematograph film or a sound recording shall not affect the separate copyright in any work, in respect of which or a substantial part of which the film or, as the case may be, the sound recording is made. What we see is that Section 34 says that where, say for example, a music is made a part of a cinematograph film, then just because it is part of that film doesn't mean that it does not have a separate existence. It is a separate work, it can have its own copyright. So depending on what kind of an arrangement exists between the composer and the producer, that will then decide how the copyright can be engaged. The Supreme Court states, beyond exhibiting the film as a cinema show, if the producer plays the song separately to attract an audience or for other reason, he infringes the composer's copyright. Anywhere, in a restaurant or aeroplane or radio station or cinema theatre, if a music is played, there comes into play the copyright of the composer or the Performing Arts Society. These are the boundaries of composite creations of art which are at once individual and collective viewed from different angles. Let us understand illustratively what the court is looking to highlight here. As we have discussed, a sound recording or a cinematograph film is a fixation. Because it's a recording and a distinct entity from its individual components, we can say that the recording itself is subject to a copyright, which doesn't affect the separate copyright in the underlying works. Meaning what? That if a certain portion from the recording itself was taken, then that would be a violation of the copyright of the sound recording producer or the cinematograph film producer. And if the music from the sound recording was used by the producer separately, separate from the recording, then that is not a copyright that the sound recording producer has. That's rather a copyright which the music composer has. And as very rightly pointed out by the Supreme Court, you can see these are the boundaries of composite creations of art which are at once individual and collective. Because this is a composite work and because Section 13 Clause 4 clearly states that the copyright in such composite work shall not affect the separate copyright if not for Section 17. Ideally, it would lead to a separate copyright existence for the musical work composer and the sound recording producer, for instance. The court then elaborates by saying, in a cosmic perspective, a thing of beauty has no boundary and is humanity's property. But in the materialist plane on which artists thrive, private and exclusive estate in art subsists. Man, the noblest work of the infinite artist, strangely enough, battles for the finite products of his art, and the secular law operating on the temporal level guards material works possessing spiritual values. The enigmatic Mona Lisa is the timeless heritage of mankind, but till liberated by the prescribed passage of time, private copyright of the human maker says hands off. A reflection of how copyright must be seen is that where society encourages the grant of copyright for fueling more copyright expressions to come into the Supreme Court is explaining how copyright creates a monopoly right in the hands of the author and what would otherwise be considered as something over which society would want to have free access to. The law of copyright ensures that this is within a boundary until the time period for which this boundary can exist has expired. Now consider whether the producer of a cinematograph film can defeat the right of the composer of music or lyricist by engaging him. You would have realized that when we discussed Section 17 Clause B and 17 Clause C, we had noted that the Copyright Act is clearly providing for two exceptions to the norm that ordinarily the author would be the first owner. We saw that while 17 Clause C is talking about a contract of service, 17 Clause B is talking about an engagement on the basis of valuable consideration, wherein the valuable consideration and the person making it would be the first owner. So, the Supreme Court says the key to the solution of this question of whether the producer of a cinematograph film can defeat the right of the composer of music or lyricist by engaging him is seen in 17B and 17C. Now, this is how the court explains it. According to the first of these provisos, which is Proviso B, when a cinematograph film producer commissions a composer of music or a lyricist for reward or valuable consideration for the purpose of making a cinematograph film or composing music or lyric thereof, that is, the sounds for incorporation or absorption in the soundtrack associated with the film, which, as already indicated, are included in a cinematograph film, he becomes the first owner of the copyright therein, and no copyright subsists in the composer of the lyric or music so composed unless there is a contract to the contrary between the composer of the lyric or music on the one hand and the producer of the cinematograph film on the other. The same result follows according to the aforesaid Proviso C if the composer of music or lyric is employed under a contract of service or apprenticeship to compose the work. It is therefore crystal clear that the rights of a music composer or lyricist can be defeated by the producer of a cinematograph film in the manner laid down in 17B and 17C. Now, what the Supreme Court has elaborated is that under 17B and 17C, what we saw as a separate existence of an underlying work and the composite work, which is the sound recording, the separation can be defeated. So, the sound recording producer, where on account of engaging a composer for valuable consideration in making a cinematograph film, the producer will be the first owner of the composition. And according to the Supreme Court, the producer can defeat the right of the composer of music. Now, ask yourself, Doesn't such first ownership create an unfair revenue concern for underlying work authors? Because there is much more to a composition than just its making in a cinematograph film. Does it not lead to unfair consequences to give first ownership to the producer? It could be contended that perhaps 17B and 17C is only focused on first ownership to the extent in which the music is recorded onto the sound recording or a cinematograph film. But that is not the case. We will see how in 17A, where such a distinction between first ownership was supposed to be made and legislatively intended, such a distinction was clearly provided within the provision. Let's look at 17A. It is saying, in the case of a literary, dramatic, or artistic work made by the author in the course of his employment by the proprietor of a newspaper, magazine, or similar periodical under a contract of service or apprenticeship for the purpose of publication in a newspaper, magazine, or similar periodical, the said proprietor shall, in the absence of any agreement to the contrary, be the first owner of the copyright in the work, in so far as the copyright relates to the publication of the work in any newspaper, magazine, or similar periodical, or to the reproduction of the work for the purposes of its being so published. But in all other respects, the author shall be the first owner of the copyright in the work. You can clearly see the distinction in wording between 17A and 17B and 17C. In 17B and 17C, we see that there is only one first owner and there is no difference in terms of copyright with respect to such first owner. You can see in 17A, there is very clearly the existence of two first owners with respect to the same work, but these first owners are first owners in respect of specific right. So for example, say for example, a cinematograph film had to be made from a report which was made by an employee in such a contract of employment as envisaged in section 17A, then permission to make such a cinematograph film will come from the author and not the newspaper. What then we can conclude is that 17B and 17C do not make any distinction between first ownership, therefore, all rights which should ideally vest with a musical work, for example, would vest with the sound recording producer. And this can create unfair revenue concerns for composers and lyricists who are getting their works added onto sound recordings. In the next session, we are going to look at copyright societies. Copyright societies are very important from any point of consideration with respect to copyright law because the authorization in real world with respect to works is done to a large extent by copyright societies. In fact, in this case also, which we had discussed today, the Indian Performing Rights Society is a copyright society. We will understand in the next two sessions what a copyright society is, how it functions, and what are some of the important changes that have been brought in through the 2012 amendment to the Indian Copyright Act, and also whether this particular interpretation brought in by the Supreme Court in 1977 has the 2012 amendment modified this through some amendment, or is this still the case? Thank you for joining me. See you all in the next session. Thank you.